and emerging technology. You've all met Ryan already. Ryan is joined by Matt Campbell, who really, I'd say, and probably in the last year, you can't think of a FOIA issue in Arkansas without Matt somehow being involved. He's the founder and senior partner of the Pinnacle Law Firm and the editor of the blog, The Blue Hog Report. Campbell has used the Freedom of Information Act to gather information about political candidates and office holders, and most notably and most recently by investigating then Lieutenant Governor Mark Darr's use of campaign and state funds. Matt's originally from Missouri. He attended law school at Washington University in St. Louis before moving here in 2006. And before he founded the Pinnacle Law Firm, he worked in the Pulaski County Public Defender's Office and with the Arkansas Supreme Court. So we're glad to have Matt and Ryan here with us today, and I guess I'll just start with Ryan. You know, as you have researched trends in FOIA, what are some of the biggest trends coming down the pike as it relates to technology and what to expect with accessing public documents on the web, in databases, things like that?
Well, it's true. There were a couple of comments earlier that government tends to not have the most up-to-date computer softwares and systems, and that's generally true. However, in terms of, you might think of like the most cutting-edge technology, and let's back it up a few years, and maybe that's where government is moving into and how it stores its records. And when you're dealing with electronic databases, it makes responding to FOIA requests easier in some ways and far more difficult in other ways. Because you can query, you can search a database and have it give you back a lot of information. And so in that sense, it's easier to find stuff, right? Everybody's experienced that. You can just search your computer and you just remember maybe a word or two that's in the title of that document, and there it is, it pulls it up. That's great. The other problem though is when you have massive amounts of information that's in a database, being able to pull back all and only what happens to be the subject of the request. So sometimes it's difficult to formulate requests. I will say too, one of the other difficulties is just in people understanding what the law requires when it comes to electronic information. More and more public records are being stored electronically, which brings up the specter of 2519-109, which I alluded to earlier, which I said is dubiously titled Special Requests for Electronic Information. And it makes people think that if you're requesting electronic information, then that transaction between the requester and the custodian proceeds under that statute, 105 or 109, and it's not true. And let me just put this little foundational point out there, and then maybe we can go off that, because I think it's important for people to understand how the law treats electronic information. And just as Tom Carpenter was saying earlier, in 2000, the legislature added this significant kind of, not even an overhaul, more of like an addendum, kind of like a Band-Aid on top of the FOIA, which in 2000 was very cutting edge in how it handled electronic information. But now, I mean, in 2000, Facebook really, I don't know if it existed or not. Google was just YouTube. I mean, those things, they weren't around. And so what needs to happen going forward is a significant overhaul. And there needs to be, I think, some kind of task force that is regularly reviewing the FOIA and has the ability to suggest changes to keep the FOIA up to date in light of how records are being used. This one last point, and then I'll be quiet and turn it over. When you are responding to a FOIA request, a person can request information in whatever format. The FOIA says medium. That means like paper, PDF, electronic information, microfilm. You can request it in whatever format it exists, and you got to turn it over in that format. Or the requester can ask the custodian, can request that the custodian transfer that paper record, for example, into, let's say, a PDF, an electronic record. And the custodian is required to do that if it is readily available. And you say, well, what does that mean? Well, there's no information on what that means. We have an opinion that tries to stake out a kind of a spectrum and try to say, well, we think that means. But here's the upshot. If it is readily available with your existing equipment as the custodian, you've got to make that conversion or that change and turn it over in the format or the medium in which it's being requested. Similar rule about formats. That's like Word document or a PDF or a WordPerfect if people still use that. Now, here's the upshot, and I'll be quiet. If you do not have the equipment to turn it over into that format in which it's been requested, you as a custodian are not under an obligation to respond to that request. I mean, to turn over that record. You don't have to turn it into the PDF, okay? But you can agree to do so. That's where the 109 comes into place, what I think should be called special agreements. You can go under 109, and under 109, you and the requester can agree to, and the statute encourages custodians to do that. But that's only after, you only get into 109, which is where you can charge for employee time. You only get into 109 if you've already antecedently determined that there is no obligation to turn it into that electronic format. People are real confused about that sometimes.
I would assume you would think that's not a good thing. If someone, if they don't have the technology, do not have to respond in the manner that you want them to.
It can be problematic. As a general rule, I try to sort of, if I'm asking for stuff in electronic form, which I do a lot just to kind of save the copy fees, I tend to phrase it as, if you have the existing hardware and software, can I get it in, email to me? If not, let me know, and I'll come pick up the paper documents. And that sort of gets you around, whether they have the technology to do it. I think what you get into, though, is, it's easy with paper records to say, I want those in PDF format. But what you're seeing is there's so much more data available. You've got, the AG's office has a Twitter account. People have Facebook accounts where they might be using Facebook Messenger to do some of their government work, just kind of chatting back and forth. Arguably, those things could be considered public records. You're not going to be able to get those in a PDF, but then the question becomes, like, how do you even get those? And I don't know that anybody's really kind of pushed for that. But I see that as kind of the next step that's going to come, is people are going to start, the same way that you've had people looking for personal emails and stuff. You'll have people saying, hey, I want every private message that's come from the direct messages from the AG's Twitter feed, and try to get those, and I think you probably see a fight there. But in general, I don't know, the ability to get it in electronic format overall, I think, is a positive. I think you just have to be careful on how you ask for it so that you don't just get nothing because they say, well, we don't have a scanner, can't do that.
How well do Arkansas entities do in providing things in electronic format? Do you see that folks are generally moving toward the digital age?
State-level offices, with one exception that I won't mention by name, are generally very good about getting everything to you in whatever format you ask for, almost always without any kind of charge, even if they have to give it to you in paper. When you get down to county and especially local levels, it's a little harder to get in electronic form. You get a lot of them saying, well, we don't have a scanner that can do that. Or then I've had the same thing where all of a sudden they say, well, you want an electronic format, that means it's 109, but they have a scanner, and no, it's not. So then it becomes this protracted fight over how much can you charge and for what. But at the state level, it's fine.
I know we have a mix of journalists and custodians in here, so I'll tread lightly with this question. But last year in Iowa, the Des Moines Register requested from the Iowa Department of Human Services, or the equivalent there, records of juveniles in their custody. They received a electronic document that had been redacted by DHS in Iowa. However, the Des Moines Register was able to undo these electronic redactions. Is this something that you see that most custodians may not be even aware of, the ability to, if you send an electronic record, someone might be able to go back to the back end and tamper with it, for instance, or I guess tinker with it better than tamper with it? And what are your suggestions to people about that?
Well, I will say, I think there's an older version of Adobe Professional that had a redaction function that didn't work correctly. And so, and it may be, I don't know, I've not heard of this case, but it may be that they did everything they were supposed to, and it was the software's fault, not their fault. And I know that that's been corrected in a subsequent, the most recent for sure, maybe the last one. But that is a problem, and I think a lot of what you're dealing with is you have to have people who have both electronic savvy and legal savvy, and being able to know what's needs to be redacted, and then how to do that in such a way that you're complying with the redaction rules, which means you have to be able to see that something's been redacted, and you can't actually see the thing that's been redacted.
Matt, any thoughts on that?
I think part of the problem comes when offices don't have the full, Adobe X, like the big full program, and they're working off either, an Office suite kind of, reader or some sort of third party that sort of approximates Adobe. And you'll see people just basically use the highlight function and go black over the text without realizing that the person who gets that can then just undo the highlighting, and that's where it is. So I would imagine it was probably something like that in Iowa, and that kind of gets back to what Eric was saying about how some of these offices they're not tech savvy, they don't have the most recent thing. Adobe X is a fairly expensive program, so a lot of them, unless it came with their scanner, aren't buying it.
I know Ryan had just brought up thought about having another task force to examine these issues. What specifically, and I'd like to ask both of you, what specifically do you think the task force should look at? What possibly do you think might be recommendations that you would like to see out of such a task force?
In terms of what they should look at, a lot of people, we've talked earlier, there was some conversation in the last panel about the amount of time that custodians have to respond to voluminous requests. And a lot of people don't realize, but in 2000, the Electronic Records Study Commissions proposed to the legislature model legislation that would increase the amount of time that a custodian had to respond to those kinds of voluminous requests, and the legislature rejected it. They did not include that in the 2000 amendments or 2001 amendments. I think that needs to be revisited precisely because as people, for the reason I said earlier, that when electronic records and the increasing use of electronic records is a two-edged sword. In some ways it's easier to get it, and in other ways, people are getting these more and more voluminous requests. And so I do think, in terms of, you want to be fair to both parties. You want to be fair to the requester, you want to be fair to the custodian, and sometimes it's physically impossible to respond within 3 days. And I think it's strange to put on the requester a guaranteed law violation. So I think that it's fair if that's revisited. I think that's.
I guess off the top of my head, the main thing would be to define some of the terms that are used in the FOIA. I mean, I can't count the number of AG opinions where the answer starts with, well, this isn't actually defined and the courts haven't interpreted it, but here's pretty much what we think it means, and that becomes consistent, but it'd still be nice to have working definitions. From a requester's side, and getting back to the technology idea, two questions I guess would be, one, the requirement, is there a requirement to get deleted records, deleted emails or whatever, if they're still recoverable? To what extent does the custodian have to do that? You see a lot of times the response is, well, we delete emails after X number of days. Well, generally, deleted emails are recoverable back to a point, so do they have to get those? And then also, with sort of the rise of understanding of the amount of information that's there in metadata, say in Word documents, if you have a Word document where the metadata might actually kind of fit the roadmap you went through in terms of, is this a public record? But then the stuff in the document itself, maybe not so much. Is there a way to segregate that? Can you still request the record to get the metadata? That's probably a question that's going to be asked at some point.
We have time for a couple audience questions, if anybody has a question for these guys. Eric?
Matt, I'm interested to know, have you run into any agency or provider that simply does not have large amounts of records available in an electronic format? Or has it come to the point to where even the smallest public office in the Forest County in Arkansas generally has many, if not most, of their records in an electronic form?
I haven't run into any that just where it seemed like it was, there was almost nothing. Everybody is keeping stuff on their computers, for better or worse, for a long time. Now, getting them to realize that, no, I can request that in the Word document form, and that's how I want it, that's been more of the pushback. I mean, it's there. It's trying to explain any medium that's, available and that kind of thing to them.
Now, I'll also speak to that. I suspect that most, at least at the state level, most state agencies are, you have new technology that comes down the pike, and you start implementing that new technology, and somebody typically kind of like, well, hey, we need to get this old stuff into this new format, and so there's just kind of like a wave as you continue forward from day one. Now we have this new stuff that's being managed and created in this nifty computer program. We have all this old stuff that we're trying to bring over. So it's probably usually the case you're going to have a system where one agency will, depending on what records you're talking about, they won't be electronic, and the other parts of their records, they will be really electronic and easy to disclose.
So hand over here, Bill.
Okay, so let's talk about what it means for an email not to exist, and then we'll go to what are the options. And real briefly, everybody's deleted an email. Yeah. Well, everybody's deleted an email unintentionally, and when you do that, you go to your recycle bin, you pull it right back. But I've never shredded a document and pulled it right back. When you double delete an email, you can't get that back. The user can't get that back. Maybe your IT can't get it back either. Yeah. Then, okay. Okay, so the answer to that is go back to the definition of a public record. Writing, recording, electronic information, video, audio that is kept. If it doesn't exist, it's not even a public record. And only, and that's why it's important to go through those steps. The FOIA is both an obligation on the part of the custodian and an ability, I call it a lever, on the part of the requester to force certain disclosures. But that lever only operates on a public record. So if the public record doesn't exist, there's no record to be disclosed. It is the preliminary final say, and a judge is going to be the ultimate person to finally say that, but it's like that with everything in the FOIA. The custodian makes those factual calls, and then that gets reviewed by a court if it does.
All right, well, thank you guys, and if you'll stay right up here, then we'll get all of our previous presenters and panelists, if you want to come up for our next panel. Let's give these guys a round of applause.